All right, welcome everyone. Hi, my name is John Vance. I'm the founder and president of Vance Wealth. We are a registered investment advisory firm, and I'm really excited today because we're going to have a conversation about estate planning 101. Don't let taxes and inflation destroy your legacy. And as you know, I've been doing these webinars since COVID started over 2 years ago now, and it's just been a great way to communicate. So I've really enjoyed these. But they're a lot more fun when I actually get to have another human being here with me. So I'm really excited to have Lisa joining me. Lisa is an estate planning attorney. She's the owner of Odom Law Group. So Lisa, welcome. Thank you for being here.
Thank you for having me.
Absolutely. So kind of just some of the housekeeping items that we're going to go through today. Lisa and I are going to talk for about 45 minutes upwards to an hour. And then at the end, we're going to do some Q&A. You do have the ability to submit questions as we're going through. And so go ahead and submit questions as we're going. I'll periodically check in, but we've been finding with the webinars, it's just more effective to answer the questions at the end. But when they're on your mind, go ahead and ask the questions. And then additionally, if we start getting into the weeds of like individual situations, I know Lisa as an attorney can't really give individual advice. So some of those items, we might deem them to be too personal in nature, where it's just, so what we'll do is we'll make sure we follow up with you individually because you're all registered. So obviously if it's a question for me, my team will follow up. If it's a question for Lisa, Lisa's team can follow up. So without further ado, let's get started. So we obviously started this topic around estate planning 101 with taxes and inflation. So we're going to just start with inflation. You know, inflation obviously is a really, it's a big topic, especially this last year. Because inflation's been running at levels not seen since the 1970s. Inflation's been pretty under control for the last 10, 15 years. But we're now seeing some real big spikes in inflation. And so I just wanted to kind of remind our audience today on, what is inflation really? And then, how do you protect yourself from it? Are there investments that over time, tend to put you in a better position in terms of cash versus the stock market or real estate? And so we're going to talk a little bit about that here as we get started. So the real interesting way to think about inflation, it's the illusion of progress, right? Because inflation is just the rising of prices, and it's typically caused by too much money chasing too few goods, right? So it causes inflation, and that's what we're seeing today. So one of the things to give you some perspective, inflation is not necessarily a bad thing. Most economists would agree that inflation of around 2 to 3% is a healthy amount of inflation for the economy. It's a manageable amount for the economy, and you actually want some inflation. So our economic engine is really built to have inflation because at the end of the day, as a capitalist country, we believe in investing in the future. We believe in investing in companies and in real estate. And the only way to keep people investing is that if you're convinced that down the road prices will be higher. And rising of prices is simply inflation. And so that's why inflation, small amounts of inflation, 2 to 3%, is really important in the economy. Why inflation is now having such a big headline risk is because inflation has been running in the 5, 6, 7, 8% range, which is causing some concern because inflation at those levels is not good for the economy. It's not healthy for your personal financial situation. So just to give you some perspective of kind of the damaging effect of inflation, at a reasonable rate at 2.5% after 30 years, $100,000 today is worth about $209,000 in the future, right? So, you can see the impact of 2.5, but look at the impact of 5% inflation, the impact of compounding. 100,000 today is the equivalent. I said worth, I meant the equivalent of 432,000 in the future. So just that tick up from 2.5 to 5 shows you how fast it devalues your purchasing power. And that's why this inflation that we're seeing right now is concerning, but just remember, it's the illusion of progress. So the next component is, well, what about investing? I don't have slides on real estate, but I would put real estate likely in the similar category as stocks. I do apologize. I know it's a little hard to read depending on what sort of screen you're on. I have 3 slides here. So this actually looks at the stock market, the bond market, and inflation going back to 1926. And I always find it an interesting stat to use going back to 1926 because it's now almost 100 years. And it also includes the Great Depression. And I think a lot of times when we look at historical numbers, we kind of figure that, if it includes the Great Depression, maybe these are returns we could expect over a long period of time. So what we have on this chart is smaller company stocks, larger stocks, which would be more like the S&P 500, government bonds, which tend to be longer term government bonds, T-bills, which are shorter term government bonds, And really T-bills are kind of what cash is generated. So that would be like savings accounts or CDs, and then inflation. So what you can see is that the box that shows the percentages. So the reason I'm showing this is stocks and real estate over a long period of time are phenomenal inflation hedges, and bonds and T-bills are not good inflation hedges. And so you can see the impact of compounding. $1 invested in 1926 in small company stocks is worth $56,000, where $1 invested in T-bills is worth $22. And then you can see the impact of inflation. So cash is just designed to keep up with inflation, and bonds are safer investments but don't do a good job protecting yourself against inflation. So that's kind of the big picture when we just look at the inflationary component. But when we then factor in, I believe this is taxes, my head is covering, yes. This is the returns of the market after taxes. And so now when you take into taxes, actually cash or T-bills are below the rate of inflation. And now government bonds are actually more in line with inflation. So you can see the impact of taxes erode away your purchasing power. So this is the same data, but just showing you the impact of taxes and the compounding effect of looking at stocks. And then the last component is, this is now after taxes and after inflation. So look at some of these crazy numbers. So T-bills on a long-term historic basis show you the impact of the rates of return is actually negative, and government bonds are barely flat. And then look at where stocks are, 5.5%. So this shows you the benefit of being a long-term investor. So the takeaway from this really should just be that when you think about where can I have inflation protection, in the short term, it's hard to hide from inflation. It does hit everybody. It hits everybody a little bit unequally, but over the long term, assets that tend to perform well over longer period of times, over these long, 10, 20, 30, 40-year cycle, tend to be stocks and real estate. So we don't know if that's going to be the 100% truth in the future, but that's been the history of the last 100 years. And we think that that general theme will likely repeat itself. So as we go into, why is my remote not working? As we go into, we're going to pivot and start getting into some of the estate planning items. But I did just want to talk and remind everyone of the benefit of home ownership. And one of the powerful benefits of home ownership is that because inflation is inherently built into our system, that a homeowner, whether a young homeowner, when you look at a homeowner that's going to basically pay off their home over a 30-year basis, they have a lot of advantages. And one of the big advantages is because of the inflationary component, is you get to buy a property today, secure debt, and you get to pay it off with today's dollars and inflated dollars. And so I know there's a lot of numbers on here, but basically the example that I have is if you have $1 million mortgage with a 3.5% interest rate, I know that's harder to get today than it was just a few months ago. Your monthly payment would be about $4,500. And so if you assume from a financial perspective that, what should my mortgage payment be of my overall gross income, I use 25%. So in this example, somebody can likely afford a mortgage of $1 million would need to take home or have gross income of about $18,000 per month. So when an individual or a couple buy a house, the first payment they make, it's 25% of their gross income. So the beauty of home ownership, if you have a 30-year fixed mortgage, is your payment stays the same. So if we now fast forward and let's assume your income grows by 5%, right? That's part inflation, part you're getting better at your job. In 20 years, your monthly gross income at 5% would be about $47,000. And your mortgage is still at $4,500, which means it now makes up 9.4% of your gross income. And in 30 years, kind of your last mortgage payment that you made, assuming you stay at your home, and I know a lot of people don't, basically it would only make up 5.8% of your gross income. So the powerful component of buying a home is you borrow in today's dollars, you get to pay it off in future inflated dollars. And that's really the power of home ownership. All right, Lisa, now I'm going to hand it off to you.
Thank you. And thanks for having me, John. So, you just talked about the importance of home ownership, and obviously the home actually tends to be one of the largest investments. Actually, real estate in general tends to be some of the largest investments that most of your, average clients at a minimum, and even your wealthy clients will have. And so then the question is, how do you protect those assets and make sure that everything has a smooth transition to your heirs, to your beneficiaries? And so the next slide is about, do you have an estate plan? And if the answer to that question is no, then you should be expecting some chaos when someone either becomes incapacitated or passes away. I do think it's interesting. A lot of times when people talk about estate planning, they think of it in the context of death only. I think that, everyone's sort of reminded of everyone sitting around talking about the last will and testament and reading it in a lawyer's office, which, by the way, in 18 years of practicing, I've never seen in my entire career. But the movies portray it, so it must be true. But estate planning can actually avoid some of these negative results and protect these assets that you've worked so hard to secure, and actually enjoy the benefits, like you said, of for inflationary reasons and other reasons. So the chaos can come in many forms. One has to do with fighting over medical treatment and financial issues. Difficulty accessing funds. I know we're going to talk about this further in a little bit. But, if someone starts to lose their faculties, how do we get someone else in to step in to make sure their bills are being paid and making sure that things are handled properly? One of the other things, people often talk about probate avoidance, but estate planning can also have conservatorship avoidance, which in my opinion, as a lawyer who's done both probates and conservatorships, as much as we avoid probate, I would avoid conservatorship 50 times over before a probate. They're really expensive and they're just a nightmare. And then determining who your guardians are going to be if you have minor children, and just preventing in general court intervention. Could you go to the next slide, John?
Yes, I do have a quick question. I got some alerts that came up. Sorry about that. I do have a question. Why,
Sure.
Because we know it's so important, why do you find that so many people delay either getting their estate plan in the first place or actually updating it? Because I feel like for us, we're constantly having it on our reminder list for clients when they come in for meetings saying, okay, hey, it's been 8 years, it's been 10 years. Okay, your children aren't minors anymore. Or hey, well, you don't have anything in place, not even healthcare directives. Like, what do you think that, are there a few things that are just causing that roadblock?
So I'm going to break it into two separate parts. So on people who don't have one at all, the reason that I believe that they don't want to do it is twofold. Either they don't want to discuss death because death is scary and it's hard to just, no parent of a minor child wants to imagine not being the one raising their children. But you can't just bury your head in the sand, because in my opinion, people who have minor children actually need the protection the most. Their minor children don't have a legal voice. So it's really important. So I understand burying your head in the sand on that, but that's unfortunately not the best, situation on that. Also price. I think that people think it's going to be exorbitantly expensive. We've taken an approach that this is not, we do estate planning because we love it and we're passionate about it. We try to charge a very reasonable fee for it. But people, it's just something that it's an offensive action, not a defensive action. So if someone dies, you're forced to pay the money. Doesn't matter what it's going to cost. But coming up with $2,000 to put together an estate plan feels very overwhelming. So that's why people won't get one initially. Once people have one, I think the reason that there's the problems with getting it updated is a couple of things. Number one, people often tell me, oh, I'm going to make more changes to this account, or we're about to sell this house and we're going to get this one, or we're going through a refinance. So we hear lots of, I won't say excuses, but lots of reasons why they think it's best to wait a little bit. Unfortunately, though, we don't have a crystal ball. So that's the downside of waiting. The other reason I think is just that they kind of think, oh, I've done it, it's done, I don't need to worry about it again. That's definitely not true, as we're going to talk about, especially when the law changes, which, for us, it's job security, but in reality, the law changes a lot based on administration, based on a lot of factors that we can't control. So I think it's important to understand what happens if you don't have an estate plan. So obviously there's chaos, but here's the realities. The next slide talks about the laws of intestacy. And intestacy is basically the laws by which we give our next of kin the assets that we have when we don't have some system in place. So if you look on the slide, you'll see that I broke it out into two separate types of property. Because interestingly, community property, if you are married and die without a will, or a trust or anything in place, 100% goes to the spouse if it's community property. Whether that's what you want, it doesn't matter, 100%. Even though under the eyes of the law, your 50% can go to whomever you want, and your spouse's 50% can go to whomever they want. But if you die without anything, it all goes to the spouse when it comes to community property. Now, with your separate property, this is an interesting issue. Half of it, if there's one child and a spouse, half of the separate property goes to the spouse and the other half goes to the one child. If there's two or more children, 2/3 goes to the children, the surviving children, and only 1/3 goes to the spouse. So it's weird because it kind of depends on the age of the children and the type of assets, but this result is not always what people want, and the estate plan can avoid that. And if you have no children or spouse, then it goes to your heirs at law, which would be your parents, your siblings, your nieces and nephews, aunts and uncles, cousins. It's basically based on the chart of consanguinity, which has to do with your blood relation, and you have no control. And fascinatingly, before it does the final thing, which is a sheets to the state if they can't find any family members, before it sheets to the state of California, the last person that could potentially get your estate if they can't find anyone is an ex-spouse. You heard it here, folks. Ex-spouse.
That's probably reason enough to get your estate plan.
Right. Most people don't want that result. So also, if you're an unrecognized domestic partnership, there is no right to inherit. That's a very negative result for long-term relationships. Whether it's regardless of type of relationship, California does not recognize common law marriage. So in some states, if you're married or if you hold yourself out as a couple for 7 to 8 years, live together, whatever, it's called a common law marriage. California does not have that. So there could be some very negative impacts from that. What if you are the caregiver you're the provider for your family and you have a partner and you never marry? If you were to die, the partner gets nothing, even if it would have been your intention to have given them everything. And by the way, that result I see so often, it's not even funny. And it's often devastating to the partner that you leave behind. If you live together and have children, it's potential that the children could get the money and the partner still doesn't. So that's not good, even if the children are minors. And what's even more crazy about that is there's no guarantee that the partner would be able to manage the money. So the partner is really put in a difficult spot. Or I think one of the saddest things I've ever seen in my career, and I experienced this firsthand, was a situation where the partners were longtime partners. One of the partners became extremely ill, was in hospice. Well, first was in the hospital, then put into hospice. And the family literally excluded the partner because they didn't approve of the homosexual relationship that underlied that particular relationship that I had to deal with. So an estate plan prevents these things from happening. And that's why they're so important. We're not forcing you to get married. We're just telling you to plan. So I'm not going to talk about a will very much today because most of the people here, if you own a home in California, you have assets that exceed $166,000, you're in the aggregate, you're probably going to want a trust. So we're going to focus on the trust today. The trust has a lot of advantages. It allows you to designate your beneficiaries. You have a lot of potential tax savings that you can do both on an estate tax level and other certain types of taxes that can be prevented, like capital gains taxes through a step up in basis, which we can explain further if we have time. There's also some asset protection that is available to your beneficiaries. It's not available to the settlers of the trust, and I'll explain who the settlers are in a second, but that's a big misconception that I'm going to do a trust for asset protection. A revocable living trust will not give you that. The estate will be managed by a trustee rather than the probate court, which gives it a lot of privacy, which most people like. I don't know about many of you in the audience, but I personally don't want what my children inherit for me to be public knowledge. So, because then it's potentially subject to, fraudsters and people who want to do harm to your family. It's also generally a lot faster and almost always is considerably less expensive than a probate. And you can just provide for a lot of contingencies. I spend a lot of time with my clients trying to understand their situation, trying to understand their family dynamic, I often ask, hey, is there anyone that should be able to live in a house after you die? Like, there's little things that people forget that, like, oh, my mom's been living with me for 20 years. Well, that's something that we should probably make sure we have a plan for. We don't want mom to be evicted. Like, there's just a lot of little things that we can do in a trust that I think make them very advantageous. And they're very easy to modify. They only have a few drawbacks. One of them is that they're a little bit more costly than a will. And you do have to keep the trust funded. And we're going to talk a lot about that today, which is really just making sure the assets are in the trust itself. And I would say this one's arguable, but they're a little bit more complicated to understand. The reason for that is mainly just because they are effective immediately. And so they can prevent conservatorship if you were incapacitated, but most people only think of them as applying when someone dies. But the truth is, the second they're signed, they're a living entity. So the next slide talks about owning and managing the trust. And the settlor of the trust is the owner of the trust. So if you came to me and said, I want to establish a trust, you are going to be the settlor. The trustee is the manager of the trust. You, as the settlor, are generally also going to be the initial manager of the trust. Interestingly, I didn't add this, but beneficiary, you are also going to be the primary beneficiary. This is the reason that when you have a trust, you don't really feel any noticeable change, even though you change titling and stuff. It's because you're the owner, the manager, and the beneficiary of it. So you're the primary. The successor trustee is a person who replaces you, whether it's because sometimes we have elderly clients who say, I no longer want to serve in this role. I want my kids to pay my bills. So that's one time where someone could resign as trustee. But most commonly, it's death or incapacity. You generally get to appoint the successor trustees, which is also an advantage from probate court, where sometimes if you have nothing in place, you can't select who you want to serve in this role. And the trustee does not have any, they have legal ownership, but not beneficial ownership. So they have no right to amend or revoke the trust. And when they take on the role as a trustee, they do so with fiduciary duties. And this is designed to keep the assets safe for the beneficiaries.
Lisa, I've heard the term like grantor trust. So grantor, is it the same as a settlor, or is that different?
Absolutely. So grantor, settlor, and trustor are interchangeable synonyms. So
Okay.
it's kind of an attorney preference. I like settlor myself, but honestly, we use grantor and trustor as well.
Okay, perfect.
So the primary function, so a trust is only worth the paper it's written on if you've actually put your assets into the trust. And when I'm describing this to my clients, I often describe it as a bucket. Like if you can imagine this humongous bucket that's going to hold all of your assets in it, that's what the trust is in sort of in theory. And you want to get all of those assets into the bucket because then the terms of the trust will govern those assets. And that's what kind of keeps the chaos down, because it provides for an orderly process if you die or incapacitated. And that process of actually transferring assets from your individual ownership to the ownership by the trust is known as funding the trust. And I would say it is one of the most critical functions of the trust. The trust process. The types of assets that are commonly transferred are your real estate, all of your banking accounts, your brokerage accounts, non-qualified annuities. Retirement accounts do not get funded into the trust at this point. We'll talk about them in a second. Your business interests, your personal property, your vehicles. I mean, the list can go on, but basically think of anything that is not a retirement account, we want to get into the trust. And your estate planning lawyer will help guide you through that process, or should help guide you through that process to ensure that that actually happens. Yeah, John.
Yeah, so I was just curious, hopefully I have the right understanding, but I feel like sometimes clients will get caught up a little bit in the semantics of, well, I'm going to open a new account. I need to go talk to my attorney about putting this in my trust. And I'm like, well, you just need to title the account in the name of the trust, and it doesn't need to be specifically called out in the trust document. So why is that accurate? And why is that misunderstanding, I think, a little bit common?
Okay, so that's a great question. And actually, I'm really glad you asked it. So most estate planning attorneys like myself have a schedule of assets that identifies all of the assets as of the date the trust is drafted that should be in the trust. That schedule of assets is often misunderstood to achieve the goal of putting it into the trust. It does not actually put the asset into the trust. It shows an intent to put it in the trust, but it does not actually do it. Assets that have a title that can be actually formally transferred in order to be in the trust need to be physically put into the trust. So you're absolutely correct. If I come to you with a trust and I say, hey, John, I want to put this in the Lisa Odom Living Trust, that asset, the second you title it that way, it's in the trust, regardless of whether it's in that schedule or not. Now, we as trust lawyers are always going to suggest that that schedule still be updated. I tend to tell my clients to look at it every 3 to 5 years, depending on how active they are and where they are in their life. But the reason I like it to be on there is just in case you ever, it's twofold. It's just in case you forget to put an asset into the trust. Although I really try to explain why you do it right from the outset. That is the best way ever to ensure that it's where it's supposed to go. But if you don't put it in, or you pull it out for some reason, it gives us another mechanism if it's on the schedule to put it into the trust down the road. Or if God forbid you passed away without it being put into the trust, we can do something known as a Hegstad petition, which is still a form of probate, but it's a much more innocuous, much easier probate process to get through. It takes about 4 months versus a year to 18 months. So there's a lot of advantages of that. You had a second part to that question that I wanted to answer, and now the answer is escaping me right now, but I'm sure it'll come back to me. But that's why we encourage people to put it in right from the outset, but always, to make sure that we update that schedule eventually. The other reason I like to have it listed on the schedule as well is that, remember, your family often doesn't know anything about your financial situation. So you pass away, the schedule, even if you put the assets in the trust, the schedule provides a nice roadmap to what it is that you have. So That's why I like it.
That makes a lot of sense.
So, and then this diagram is just meant to be sort of a visual of what I just explained. So you see my bucket, and then you see a house and a car and money and jewelry. Then you also see life insurance in the 401k. Now, they're going to be coordinated with the estate plan, but they're not going to actually, generally speaking, not going to be outright named in the trust. And I'll explain why as we go to the next slide. If you want to go ahead and shift forward. So there's certain assets that we can't fund into a trust or that we choose not to. So life insurance and qualified annuities and retirement accounts and pension plans. And so even though we don't typically put them into the trust outright, we definitely still coordinate with them with the trust. Although retirement accounts changed dramatically this last year in 2020, or 2 years ago in 2020. But with life insurance, I generally recommend that, absent some reason not to, we generally have the contingent or the primary beneficiary always be the trust. There is really very little downside. We include language that excludes it from creditors' rights issues. So if you name a trust as the beneficiary of a life insurance policy, let's say you had a $5 million judgment against you, that life insurance is carved out, even if you've named the trust as the beneficiary, because my particular trust has language to prevent from creditors being able to come at that life insurance. And that's because that's the general rule. If I had life insurance and John was the beneficiary of it, even if John had a pending lawsuit, that doesn't necessarily entitle the litigant on the other side to come after that 5 million. There's some special rules when it comes to life insurance. In my trust, we preserve those rights, even though you've named the trust as the beneficiary. So that's why there's really no downside to naming the trust as a beneficiary of the life insurance in most cases. But to access life insurance or annuities or retirement accounts during life, but in incapacity event, you have to rely on a power of attorney. Unlike all of the other assets that are actually put in the trust, they're governed by the trust document. The power of attorney is how we, through an estate plan, try to coordinate this when we have an incapacity event during your life. And then when you pass away, the beneficiary designation is how we coordinate the trust with the life insurance posthumously once you die. Now, retirement accounts are a very interesting situation. So prior to what's known as the Secure Act of 2020, there was a loophole in sort of tax rules. I mean, it was a known loophole, so it wasn't like it was some kind of, big unknown. But there was this ability to stretch an IRA, which John could give you a ton of information about stretching an IRA. But I know from personal experience that people who could stretch an IRA could make their $1 million in their IRA go on for generations and generations. There was a lot of benefit to it. And we used to be able to, the IRS had promulgated some regulations that allowed us to even stretch an IRA through a trust. So what you literally could provide for generations to come. And so people who would have estate planned with me many years ago, any time up to 2019, had these look back provisions. They had all these regulations and language in their trust that allowed them to stretch. Oh, Congress, we changed everything in 2020. And it was on January 1st of 2020. And the law changed dramatically. There were some cool things about it, like you no longer were forced to take required mandatory distributions at 70 and a half. Now you can take them at 72. But our beneficiary designations and our coordination with our trust changed dramatically. And the stretch feature changed dramatically. And so you want to go to the next slide, John? Do you want to speak to this one a little bit, or do you want me to?
Well, I mean, I think on here, I think we put some details here on the Secure Act. Is that what you wanted to go through a little bit, is going through some of the provisions on here? Yeah, so I think that's a good idea. I can chime in if needed.
Okay. So the Secure Act, the big thing it did, like I said, it would change our required mandatory distribution dates up by 1.5 years. So now you can hold your money tax-free till 72. However, it eliminated the ability to stretch for most of our beneficiaries, which means that most beneficiaries have to receive all of the monies in the IRA within 10 years. So that was a much different, a very different result than previously, especially from a tax perspective. So, I have an example here. If Annie died, leaving her 50-year-old son as a sole beneficiary of her IRA, prior to 2020, he would have been able to stretch it, which what that meant was that, so it turns out that the actuarial chart for her son would have been 34.2 years. So basically, he would have had to take a required mandatory distribution over 34.2 years. So let's say he died at year 22. Now his named beneficiaries could then further stretch. So you see that the monies can continue to grow tax-free without really any consequences, and it could go for a really long time, which is why it was a substantial loophole to the IRS, and the IRS was losing considerable tax funds. So I get that. Following the Secure Act, son would have to fully distribute the money by the time he was 60 years of age. So that brings up a lot of interest. There's some exceptions. Surviving spouse is an exception to that. Minor children. So if you have a 10-year-old let's say you have a 2-year-old who inherits, that 2-year-old is going to be able to keep it in for all the way till they're of age. So at least 16 years, depending on if it ascribes to the Uniform Gift to Minors Act, which might push you to 21 years of age. So it's a little bit longer of a stretch potentially. Chronically ill or disabled individuals, if you have a chronically ill or disabled child, that stretch can be much longer. You could still use the trust for those individuals as well. So there's some planning that can be done there. Or if you're giving your assets, let's say you have a long-term partner and your partner is 5 years younger than you, that 10-year rule does not apply to that person either. But otherwise, it has to be fully distributed. So I'm sorry, were you going to say something?
Yeah, sorry, I didn't mean to cut you off. I mean, this is an area where there's a lot of planning that falls into this because, the stretch provision basically allowed, using your example, that 34.2 years, it's like a 3% distribution, right? So depending on the size of the inheritance, if it's $1 million IRA, that's 30,000. If it's even larger, you can kind of get an idea of how much would come out. So now that there's a 10, it's got to be paid out in 10 years. It does require some planning, right? Because if the beneficiary is inheriting it and they're still working, then it's like, okay, do I want to take it out equally? Do I want to take it out lump sum? So you have to be a lot more thoughtful around this to really help to mitigate some of that tax liability. We're also even having these conversations with our clients that are now in their 60s, 70s, and 80s, recognizing that like, hey, my kids are making more money than I am. I don't want to burden them with this big tax bill. So we're being a lot more strategic with looking at their tax liability and saying, well, maybe we should be actually taking a little bit more money out, paying the taxes, because when you leave the money to your children, it'll be more tax efficient. And so it's opened up the dialogue for a lot more thoughtful planning. And I think, unfortunately, a lot of us are hardwired to kind of run through and do things the same old way. And then you don't recognize it, like, wait, hold on, there's actually some decisions to be made. So that's been kind of I guess the fun and the change, because we really love planning. I mean, the planning component is like, how can we build a strategy that's going to help you, help your family? And so when we go through these rules, that's where you have to start paying more attention to this, because that loophole really did provide a gift, and it allowed people to be a little bit careless with it. They just knew, hey, it could stretch and I don't have to worry about it as much. And now it's a much bigger issue.
Absolutely. I mean, from my perspective, it creates a lot of interesting, first, I agree with you. It creates a lot of creativity and strategy that you can employ, but it also took away what everybody sort of just took as an automatic. And it has, I mean, look, if a 50-year-old is still active in their career, right? So in my example here, we have a 50-year-old. Let's pretend that 50-year-old is a physician. Well, 50-year-old physician might not want to, this could be a huge disaster for this person. They make a lot of money. This could be a 35, 40% to them, in addition to their already ridiculous taxes. And this is not necessarily a benefit to them. And there is a strategy in it. Like, what if 50-year-old was planning on retiring at 58? Well, now all of a sudden there could be a strategy to wait the 8 years before taking the distribution, so that their salary is much less. I know that, if you have a 21-year-old, like, even though you don't normally want to give a 21-year-old $1 million, that's also ill-advised. But the 21-year-old probably doesn't have a full-time job making a ton of money. So maybe there's, some benefit in distributing more early on. So it becomes, for planners, for both for CPAs, financial planners, and attorneys, we really have to look at it much more carefully now. But I agree. I think it's actually a gift. But
yeah. And can I ask you a question on that? I don't know if I want to get too much into the weeds, but using that example of either like a young beneficiary or maybe like a financially irresponsible beneficiary. So if you can still name the trust as the beneficiary of the IRA, and then once they take the distribution, that it still remains in the trust, and they got to pay taxes, but can you actually control that money stays in the trust if you have any restricted payouts?
Yes, you can.
Okay.
You can do that. And unfortunately, like you just perfectly identified, there are, especially, I mean, this pandemic generation of minors that are kind of coming up are a little bit less mature than maybe the millennial or Gen X, people who preceded them. And yeah, there's definitely still some trust strategy that can be used with these. But yeah, in most cases, and for most just general people who the kids are pretty good, pretty mature, most of the time they're just going to name their kids individually and go from there, because the trust tax rate is higher than the individual tax rate in most cases.
Which is obviously not great. So
exactly.
Okay. Well, let's pivot. I'm going to jump in. I have just this one slide, and then I think I'll be pivoting back to you for a couple other things. So our clients that are on the call, they probably recognize that during their review meetings with their financial advisor that we've been asking them for their trusted contacts. And basically what a trusted contact is, the SEC is requiring us to have on file a trusted contact. It's really in place for all new accounts. They can't really force us to for older accounts, but we're trying to add them because we want to be up to date. And basically it's an individual connected to the client that basically the advisor, so someone on our team, can actually reach out for the following reasons. The client's unreachable and we're concerned. Number two, the concerns are concerns of cognitive decline. Like, we're noticing some memory slippage, something's going on, and we just want to kind of make the trusted contact aware, and then believe there may be some financial elder abuse happening. And so by putting that in place, by having a trusted contact, if we're starting to sense that, we're kind of the first line of defense, right? So we want to be having the conversations and then addressing, are these issues? And so that, because we're having a lot of frequent conversations with clients, they've really required the advisors to be in this role. So the reason I wanted to mention this is, obviously this is something we're doing, but it's starting to bring up some other conversations from an estate planning conversation, because Lisa's going to go through the kind of the do's and don'ts, but we hear a lot around like, oh, I'm paying my mother's bills. Well, do you have power of attorney? No. Are you the trustee? No. Well, technically you can't. So I want Lisa to kind of speak to some of these issues, because I think that even though we all, like, if you're helping out a parent or a friend that is maybe have some cognitive decline, you want to be cautious and careful about, some of the laws you might be violating if you're helping in good conscience, but you're actually doing things you should not be doing. So again, our purpose is because we're required to, but we also want to just have that extra layer of defense, so that as our clients get older, and we all are, right? We're all getting older, that we're aware of what's happening, and that we can alert anyone that's close to you. Again, that's why we call it the trusted contact. So let let Lisa jump on this one, because this is a big item.
So I love the idea of a trusted contact from a practical perspective. I actually had a client, interestingly enough, today, who I believe is starting to suffer from diminished capacity issues or some mental illness, and has attempted or endeavored to revoke her power of attorney and then put it back in place. Probably this is the fourth time. And unfortunately, I, as her estate planning lawyer, am constrained by attorney-client privilege, because even though I believe that she has a mental infirmity, I am not allowed to disclose it to anyone. I have to hope to God, which I do, that one of her family members catches it and reports it, because I don't know what to do at this point. I have called the state ethics bar 50 times about this client because I'm not sure what to do. And so this is a really big issue. And we even had like a trust protector. Your trusted contact, in her own estate planning documents, we had put a trust protector. She's fired that person 20 times over. I mean, this is a very challenging area. And as our baby boomers are starting to face the realities of diminished capacity and stuff, this is going to continue to be a really hot topic. Unfortunately, the question of whether to act or not act is really challenging, especially in California. So understand that when you act under a power of attorney, a durable power of attorney for financial management, you do so with something known as fiduciary duties, which means you owe a duty of loyalty, a duty to act in the best interest of the grantor. You have to act properly, and if you don't, not only can you potentially face civil penalties, but you could actually face criminal liability. I actually have a client right now who is facing criminal charges due to a breach of fiduciary situation. I've never seen that in my entire career, but alas, here we are. The biggest issue that we have in California with this acting without authority are claims of elder abuse. California has a very robust, very elder-friendly law for elder abuse that basically makes a presumption that someone is being abused if certain financial mishaps happen on their behalf and they are over the age of 65. Elder abuse is becoming so prevalent that even in normal probate or in normal estate planning, when we're dealing with someone who's over the age of 65, we have to be very, very careful. I had a client the other day who brought her daughter. She told the daughter she's of an advanced age. She told the daughter she wanted to remove someone from the trust. The daughter started to have a hissy fit. I was like, you have to leave. Goodbye. Like, I wasn't trying to be mean, but I was like, and I told her when she was finally invited back, I'm saving you from being charged with elder abuse. Like, that's basically, and by the way, elder abuse also has a potential criminal component. So elder abuse is the California protecting the person who's perceived as the underdog. The elder person, as they get older, sometimes have less ability to fight undue influence and other things. And the other problem that we have with people who are starting to actually deal with diminished capacity is they don't trust anyone. And so the people who are closest to them, they start to think are actually trying to harm them. So the question of to act or not to act becomes very hard. And I know a lot of people will act without formal authority, and I would caution against it because of these issues. So claims of elder abuse is definitely one. You could get a lot of opposition from our client who is now has diminished capacity, because again, they think that you're trying to do something to harm them. And that's really how you walk yourself right into that elder abuse case, is because they don't trust you, and not because you've done anything wrong. You could be acting completely by the books, but because they're starting to lose their faculties, they think that you're doing something harmful. And this is one of the most devastating facets of dementia and Alzheimer's, truth be told. Also, if you're acting on behalf of them, it makes it really hard to have identifiable evidence that they are indeed incapacitated. Whereas if you catch them, one of the most common things that I've seen in my career, a few of my clients have had this, where they started writing checks to like random charities that they had no connection with. Or one of my clients gave some guy overseas $50,000 just because it seemed like a good idea. She didn't know him. That's not normal behavior, but that enabled us to get a letter of incapacity, which enabled our client, our ultimate client, to act properly with authority and with fiduciary duties, which, even though those fiduciary duties are designed to protect the client or the original testator, they also protect you because they allow someone to know that you're acting in their best interest. There's also, obviously, I talked about conservatorship earlier. Conservatorship is not a fun process. We would definitely always recommend avoiding it. Again, more periods of chaos when nobody knows what the settler wants to do. This could be just a disaster. And so acting with the fiduciary duty, acting under a power of attorney, really does say the reason we do those when someone has capacity is so that when they don't have capacity, we're still acting in accordance with their wishes when they were of sound mind. So it's better to be proactive in this way. And that's why we use either the power to appoint a co-trustee, the naming an agent under a power of attorney. Those are ways in which the trusted contact concept that you identify, it's really ideal if it could be coordinated with that power of attorney or that trust document somehow. So we just make sure that you're acting with fiduciary duty so you have some protection and you're not charged with an elder abuse case down the road.
Okay. Sounds good. Oh.
And oh yeah, so I just did a little, I always take the time to let everyone know that the internet is not your friend. Google is not a lawyer. Unfortunately, a lot of times we see people do some interesting things when they're trying to self-estate plan. And one of them is adding beneficiaries to title. It's my least favorite thing I see. You lose so much when you do that. When you let someone inherit your property, as of right now, there is a law known as the step up in basis. So basically what that means is if you acquired your property for $100,000 and when you die, it's worth $1 million, your family, if they inherit it, get to walk into that $1 million value. If they sell it the very next day, they pay $0 in capital gains. If you add them to title, they walk into the basis that you have. So if you never put an ounce of money into the house, they walk into $100,000. Maybe you put a couple $100,000 into the house, who knows? Maybe it's a little bit, maybe it's not so bad, but rarely does it get you out of capital gains all the way around, which is about 20% for the feds and 10% for the state. So that's a really unintended consequence. The other problem with adding beneficiaries to title is, guess what you've given your beneficiaries? An asset for their creditors to go after. So if they file a bankruptcy, if they hit a doctor while they're driving, all sorts of things that can happen in the parade of terribles that are the realities of life, you have now potentially subjected your asset to their creditors. And I think that that's ill-advised. The other problem with it is that you have potential disinheritance. You definitely could disinherit. If you named your two children as joint tenants with you, so it's a husband and a wife and son and daughter dies, and you would have wanted daughter's children to take daughter's share, but you had it as joint tenancy, 100% goes to son. If son dies a week later and has kids, his kids get all of it, your other grandkids get none of it, and that is just the way it goes. Don't be a Google lawyer. It's just not a good idea. There's also some gift tax issues. People think, oh, I'm just going to add my kids to title. Well, did you file a lifetime gift tax return? Like, have you reported it properly? You just create so many issues. And then the other issue is this I had to deal with very recently. I had a client who was going to sue her brother because he had gone to the 80-year-old mother and said, I just need a title, I'll share it with my sister. Well, in a shocking turn of events, that didn't happen. And guess who is now being pursued for elder abuse? It's not wise. It's not wise, because under the law, if you make a change like that to someone who's over the age of 65, when they have effectively disinherited their other child, you're likely to get sued, potentially criminally, definitely civilly. So
got to be careful there.
Gotta be careful.
See those issues show up. Let me see if I can get this back on track. So real quick, we did have a question came in that I can answer. It talked about like, what about Roth IRAs, how that's impacted? I mean, basically on the 10-year payout, the Roth IRAs are impacted, so it's not going to be able to stretch. But with the Roth IRAs, the money still comes out tax-free as long as you meet the requirements. And generally, most of the distributions from Roth IRAs are tax-free. So probably, unless you needed the cash flow, our recommendations allow that money to compound for 10 years, so you can get tax-free growth for 10 years and then take it out at the end. But yes, it does apply to Roth. So Roths will not be able to be stretched into the next generation tax-free. Okay. So we kind of started off with like inflation and the impact of, why some small inflation is good, high inflation is not so good. We covered a lot of the, just do's and don'ts of estate planning, covered living trust, just to give you some basics there. What I do want to wrap up, and it was just helpful to hear that conversation, because we see a lot of the horror stories on our end. I mean, Lisa probably sees way more than we do, but we try to sometimes be that first line of defense of, you can't do that. Go talk to your attorney, right? It's like, oh no, I read this. You can't do that. Go talk to your attorney. So it's like, you have to follow the protocol. And we're talking about assets. These mistakes or these, innocent mistakes can actually cost you a lot of money and potentially get you into trouble. So just be more careful there. As we wrap up, we're going to talk about some tax strategies, and we're going to focus in a couple areas. We'll talk about tax loss harvesting, and then we'll talk about for charitably inclined. So just given time, we are coming up on the half hour. We got about 5 minutes till that. I'm probably going to need about 10 more. So hopefully we left some good tax tips for the end, so you'll stick around. But we should be done fairly shortly. So one of the things that I see too often, people who are charitably inclined, they're still in the habit of either writing checks, giving cash. And frankly, if you have a portfolio of appreciated investments, it's way better to give appreciated investments. I mean, the tax savings is so much greater. So if you're in that habit of giving cash, I know it's hard, especially if it's for like a church, because you're very inclined to just walk in and hand a check, or it's like a weekly give or a monthly give. Donating appreciated securities is way more effective, because you get to get rid of the capital gain tax, and on top of that, you get an income tax deduction because of the charitable gift. So just to kind of illustrate this, if you were going to give, on the left-hand side, I have a cash or check gift, and then I have on the right-hand side an appreciated investment. So let's say you're going to make a $10,000 gift, and you're in the 50% tax bracket. Use whatever tax bracket applies to you. By making this gift and assuming you're itemizing your deductions, you get a $5,000 tax savings. And that's why, that's the benefit of giving to charity. So if you take the appreciated investments approach, let's say you bought something for $2,000, whatever that is. It could be an ETF, it could be an individual stock. You bought it for $2,000. It's now worth $10,000. You've held it for longer than a year, so over 365 days. You have a gain of $8,000 or an unrealized gain. Now, we know if you sold that, you'd have to pay tax on the unrealized gain. But instead of selling it, if you just gave it to the charity, gave it directly to the charity would receive that $10,000 of securities. They can sell it tax-free because they are a qualified charity. And by doing this, your tax savings rates is like 78%, because you're saving the capital gains tax that you would pay, and you're saving the income tax at federal and state. So way more powerful. Now, this was an example. Everyone's situation is going to be a little bit different, but this is a way more impactful way of doing it. The other thing that we do recommend, and I have one for myself, and this is my preferred way of giving, and I think this is not just for, you think about like a foundation. This is a donor advised fund. This can be set up. I think the minimums are like $20,000. The beauty of a donor advised fund is, if you think about when you're giving to charities, you likely want to give on a regular basis. You want to give every month, or every week, or whatever the cadence is, or maybe just once a year, right? But you want to give on a regular basis. Well, the reality is, if you're going to give appreciated investments, we know that sometimes the stock markets are really doing well. And like right now, we've seen a correction, right? So, last year, as the markets were finishing a strong year, I was making larger and larger donations to my donor advised fund because I wanted to get the tax write-off for last year, but I also had assets that had gone up so much in value. I wanted to give them at the time I control. So the beauty of a donor advised fund is you get to make the donations of appreciated securities when you think it's appropriate based on the investment, based on what's happening in the markets. And then you get to dole it out of the donor advised fund on your schedule when you want to give to the charity. So it really serves two purposes. It's kind of like you get to sell it when you want, but you're really not selling it. You're putting into this fund. So these are great tools to really maximize your gifts. And one of the greatest reasons for this as well is if you need a big tax write-off and you want to give 50,000 or 100,000, most people don't want to give one time that much to a charity. But by putting in a donor advised fund, you can put 100,000 and you get the tax deduction today, and then you get to dole it out next year over your lifetime. So it really offers some really nice provisions to be able to give over a longer period of time, and you get to really control the outcome. So I think we had a question came in here. Let me see. What is preferable, a donor advised fund or setting up a foundation? Are they both taxed? So maybe, Lisa, I don't know if you want to shed a little bit on that. I mean, generally, and I maybe get the feedback from you, donor advised funds are really easy to set up. There's minimal cost. It's really minimal cost. The foundation, you have some hoops you have to jump through. There's legal costs, there's tax costs, there's maybe you have to set up a board. Can you walk through like some of the protocols if someone opts for a family foundation or a private foundation versus just using a kind of an off-the-shelf donor advised fund strategy?
Yeah, the donor advised fund is going to be substantially less expensive and substantially easier. I love my foundation work. I have a lot of clients who have foundations either through their trust or who we've done a couple of trust administrations where someone left to a foundation. I mean, it's great for us because it's a nonprofit. We get to work with the clients continually. I mean, I was just invited to an event for a scholarship fund that we manage, that you're familiar with too, I believe. And that it's really cool and it's very rewarding, but it does require a board. It does require maintenance of 501 status for the tax-free, for income to be income tax-free. It's just definitely a lot more work and a lot more effort. But on the flip side, it does allow you to leave a legacy. And if that's really important to someone, then that could be a very cool thing to do. I know that even for myself, I did very well in law school. I had an endowed scholarship that was from a family who gave to the person in my position in my law school class every single year. So, I mean, there's a lot, I mean, that family will never be forgotten by me. They changed my life. I had 2 full years of free law school because of it. So it is a cool legacy that you can do through a charitable foundation that you have either set up now or set up as part of your trust itself. But cost-wise, effort-wise, it is a lot more, and a donor advised fund is a lot less expensive. It's a lot easier to manage. That's definitely a preference on the client side and what they're looking to do. I would say from an ease of administration, the donor advised fund all the way. Okay. For the perspective of a legacy, it would be pretty much, generally speaking, the foundation all the way. So it's really a matter of preference, but the foundation is going to be legal work, accountancy work. It's definitely a lot more time. Yeah, and more time. And more time.
So we have another question that I think I can answer, and I don't know if there's a trust component, but can we assign beneficiaries on our donor advised fund? The answer is yes. Most of the time, it's likely your children. And so I don't know if you would want to name the trust. I think you would want to actually name individuals, but I'm not positive on that, Lisa.
I'm not either, but I'm pretty sure you're right. I think you would name the individuals, but I would have to look at that. I don't know that answer right offhand.
So in our experience, because we obviously work with people that have family foundations, when it's $1 million and up, the family foundation can, at that level, can justify some of the legal and tax costs. When it's a few $100,000, you're just going to get eaten up in fees and time. And it's, in our opinion, it's not worth it, with the exception of what Lisa, Absolutely. The example Lisa used, when you're giving out of a donor advised fund, it has to go to a qualified 501c3 charity, when you set up a family foundation, you can be more creative because you have a board and you are the charity. You can have a provision to do scholarship and have more flexibility, where out of a donor advised fund, you can't just say, hey, I like this kid, Johnny, down the street. I'm going to give him out of my donor advised fund. He's not a charity. So there are some restrictions. And so again, it just depends on the amount we're talking about, but hopefully that was helpful, just kind of big picture. The last thing that Lisa and I didn't really get into on the IRAs. So one of the things that we're noticing with the IRAs is that you do have the ability to give, and this has been in place, but you can give do what's called a qualified charitable distribution. This is a really powerful way to give out of your IRAs more tax efficiently. So the two components you can see some of the details on here, but if you're going to give directly from your IRA, it must be a qualified 501c3 charity. The good news about this is this does qualify as part of your required minimum distribution. So if you're taking a required minimum distribution and you don't really need all the money and you're already giving it to charity, this can be a very effective way to give directly to the charity. It reduces your modified adjusted gross income for the Medicare calculation, which is really powerful because we all know as you get into Medicare age, your premiums are based on how much income that you make. And when you hit certain tiers, your premiums can jump. So this is a powerful way for us to reduce some of that Medicare exposure by doing proper planning around the QCDs. The other thing we didn't get into as well is now that the stretch provision is not allowed beyond that 10-year window. If you are charitably inclined, one of the things, and I know Lisa does this, is if you have charitable intent with your estate planning, naming charities as part of your key beneficiaries of the IRA is one of the best ways to basically give more of your entire estate. Because remember, when your beneficiaries, like your children, inherit the IRA, they have to take the money out and pay tax. If a charity inherits it or is gifted it, they get to cash it in without having to pay the tax. So it's a much more effective way to give to charities. And I don't know if you have anything to add to that.
No, I agree with you though in every way. The things that you can do using qualified charitable distributions and generally just listing charities as beneficiaries to IRAs can help on a lot of taxation levels depending on the circumstances. So it's a strategy that we use even in some of our, not so complicated trusts. In certain circumstances, it just makes sense. So
yeah. And then you can see a note on here, checks must be cashed in the same calendar year it was distributed. So what we recommend, if you're going to do QCDs, don't do it at year end. Like, start this process now so you can get these cash in the hands of the beneficiaries to get these checks cashed. So I'm going to do this at like a lightning speed. So we've done some separate webinars on this, but this is just, I want to go through this concept of tax loss harvesting. So nobody's happy right now. The markets have been really volatile. When we kind of measure from, how much things have sold off, depending on what index you're looking at, we're seeing sell off of anywhere from 20 to 30% in the major stock market indices. So when that happens, as an investment firm, we look at the tax planning opportunities that we can identify for clients that can help save money for now and also for the future. So this concept is known as tax loss harvesting. It's basically finding losses in the portfolio, harvesting those, which we know can be used as future assets to offset future gains. So I'm going to give you a quick example. I'm happy to share this slideshow. I think everyone who's on here, you'll get a copy of this deck. So if this is too fast, I apologize, but I just want to make sure we get through it so we can wrap up. So I'm using a hypothetical example here of about a $5 million portfolio. The asset allocation is a 60-40, so 60 in growth type investments, primarily in stock related, 40% in fixed, which would be primarily bonds and cash. So we recognize that by splitting that, you have 3 million that's long-term focused in stocks, and 2 million that's in shorter term focused accounts. This client, as an example, is hypothetical, needs $200,000 every year to live off of. So that's the spend that's coming out of this account, which is about a 4% withdrawal rate. So when you just take the buy and hold strategy, which unfortunately is what we see too often, and we do preach buy and hold, but when we have volatility to the downside, you do have to recognize if you're just buy and hold, you're missing opportunities to be more strategic with your tax dollars and be more strategic with your future tax liability. So I'm just carving out this growth part of the portfolio. So let's just take on the left-hand side, the initial investment is 3 million, right? That's 60% of the $5 million portfolio. The blue represents value. The markets go down 20%. So immediately you have an unrealized loss of 600,000. So your account is worth 2.4 million. You've lost that 600,000. And now, the market rebounds and The market finishes up 10% for the year. Now, if you look on there, the purple represents unrealized gain. So now it's rebounded, you're at 3.3 million and you're like, okay, that volatility I didn't enjoy, but we're back to positive and you're happy. At the end of the day, the investor needs their $200,000, right? So at the end of the year, we're like, all right, let's take $200,000 out. Because of that, you're going to have 20,000 of realized capital gains. And at the 30% tax liability, you're going to owe 6,000 in tax. Not a huge tax liability, but nonetheless, still a tax liability. If you take a tax loss harvesting approach, we're going to go through, we added another column here. So if you notice, we have the same scenario, $3 million investment, same 20% decline, lost 600,000. And then what you notice is it's called, we actually do trades in the account, which is called loss harvesting. So now that turns from red to green. So now we have this realized loss, which is $600,000. Now, same thing happens, the market recovers. So you're back to the end of the year, you're at 3.3 million. So look what happens in the account. You have booked a $600,000 realized loss. You now have an unrealized gain of 900,000. But guess what? You don't have to pay tax on the unrealized gain until you sell. Well, again, the investor needs the $200,000 to live off of, right? That's their annual withdrawal. So by doing so, and just trust me on the numbers, but you'll realize a $54,000 capital gain, but there's no tax liability because you can offset that gain against the 600,000. And not only that, you now have a loss carry forward worth 545,000 that we can carry forward for future years. And then you can take a $3,000 tax deduction on your 1040. So by doing this scenario, while it's painful to go through the down and the up, we're able to create this tax asset. So that means that next year, if you sell a piece of real estate that had a $500,000 gain, you could offset this entire loss against that gain. And if you don't have any gains, then you use $3,000 a year against ordinary income, or any year where you have any realized gains, we can use that. So it's a really powerful tax asset. So that was kind of a quick explanation. I don't know, Lisa, if you have any questions on that. I don't know if you've seen me kind of go through that illustration, but too often than not, those that have a decent sized financial portfolio, if they're not engaged in that tax loss harvesting, they're truly missing some really good opportunities to save future taxes.
That was really helpful.
Just as a reminder, we're going to wrap up. I don't see a lot of questions, and I think we ran a little bit long. But if anyone, you can reach out to our office if you want to get connected with Lisa. We'll put her contact info in our follow-ups because we always send out the recording as well as the PowerPoint. If anyone is on this as either a guest or a prospective client of Vance Wealth, please, you're welcome to sign up for a 30-minute consultation with someone on my team. And then also our next webinar will be on June 21st. I think we are going to address the topic around, are we heading into a recession and what that might mean for your investments? And it looks like I do have, I don't have a Q&A, but I do have a comment. It says, great discussion, John and Lisa. It's always great to learn from you both. So thanks, Dan.
Thank you.
All right, perfect. So Lisa, it was a lot of fun. It's much more enjoyable because the crowd gets to hear me talk, but I have no one to have dialogue with. So thank you for joining me tonight, and hopefully we can do this again soon.
Me. Thank you for
having
me. Have a great night, everyone.
Okay, thanks, Lisa.
Bye.
Bye.